officer. So if you are accused of one or more misdemeanor offenses, please keep this information in mind. You have a right to remain silent. Anything you choose to say about the facts of the case during the course of this virtual proceeding that's not only recorded but live streamed, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we have attorneys from the Fulton County Public Defender's Office or from our conflict defense list who will represent you. Let's begin with courtroom 2. Who do we have first, please?
Good afternoon. Good afternoon, Judge Law. We're going to go with position number 8. Ms. McMahon, she has a private attorney.
Okay. This is Erin McMahon, accused of 3 separate counts of misdemeanor stalking. Her accusation number is 23 CR 002798F. Ms. McMahon, you've been advised of your right to remain silent, and your attorney is Mr. Justin Slisman. I understand this is her first arrest. So, Ms. Falk, what is your recommendation for Ms. McMahon?
Your Honor, I just want to put some facts on the record. Mr. Steinfeld is here and would like to speak, I believe, so I would like to sound for him as well. This, it was a persistent pattern of stalking, which is why the state did 3 charges instead of the 1 single charge of stalking, because of the 3 points of contact from November 1st, 2022 to February 13th of 2023. The November 1st, 2022 incident, which is count 3 of our accusation, was where the defendant texted Mr. Steinfeld stating, "I know who you were with. Your brother Dylan was not home. I know you were not out with your friends." On February 11th of 2023, Mr. Steinfeld went to the Massage Envy at 650 Ponce de Leon Avenue in Atlanta, returned to his car, and found a note on his windshield saying "good massage," which he believed was from the defendant. At that point, Mr. Steinfeld stated he was in a constant state of panic. He believed that the defendant was somehow following him. This culminated in an incident on February 13th of 2023, which is our first count, where the defendant went to a class at Core Power Yoga at 650 North Avenue. And when he left, he saw the defendant standing by his vehicle. At that point, the defendant demanded he speak with her. Mr. Steinfeld understandably became alarmed, called his father, who told him to not speak to her, get away from her. Mr. Steinfeld went and found a security officer and told him the defendant had been stalking him. The security officer is actually the one who escorted the defendant off the property and gave Mr. Steinfeld an important piece of information, which is he needed to have his vehicle checked for a tracking device. Mr. Steinfeld then took his vehicle to a mechanic who found the device in a magnetic box underneath the vehicle. At that point, this is on February 13th, Bruce Steinfeld, who's the victim of Mr. Zachary Steinfeld, received a call from the defendant's mother, and the defendant was also on the phone. At that point, Mr. Steinfeld asked the defendant, and this is Mr. Bruce Steinfeld, the father, if the defendant was aware that placing a tracker on Zachary Steinfeld's car was illegal, and she stated yes, she understood that. The phone logs that Bruce Steinfeld provided to the police show that Jackie McMahon, who's the defendant's mother, called Mr. Bruce Steinfeld on February 13th, 2023. Also, the officers took an additional step into order for the tracking device information and obtain the subscriber information, which shows that the defendant was the subscriber and of the tracking device. It was created on October 21st, 2022, which was a month before he began getting these phone calls and messages, and then was canceled 2 days after he located the tracker on his car, February 15th of 2023. We have had an opportunity to speak with Mr. Steinfeld. He stated that the defendant is his ex-girlfriend. He stated that she has been stalking and harassing him for months. He filed a TPO in November of 2022 because of this, when this incident started. But and it actually began with her busting out his brother's window on his car. But the temporary protective order, which was 22 CV 372435, was dismissed because he had been unable to serve her. He then took out another TPO on February 23rd, 2023, after he found the tracking device and after she admitted to it, and that's 23 CV 376585, which was granted and which was served on the defendant. So she does have a TPO in place to stay away from Mr. Steinfeld. He stated that she has been harassing him and other women that he is dating by texting and emailing them. He said he's very afraid of the defendant. He's always looking over his shoulder, and he believes that this will escalate into becoming something. So sorry.
I beg your pardon, sorry.
But-
All right, so he
And then-
wants to stay, he's already got a protective order, but he feels that she may violate it?
He thinks this will definitely escalate to something violent given the nature of what has been going on. And he,
If I may,
well, Mr. Steinfeld, I will give you an opportunity to speak. We will absolutely give you an opportunity to speak with the court. He has stated that he feels that because he is a man and that this is a woman, that his concerns are maybe not being taken as seriously, which I'm going to be honest, in prosecution, that often happens where the male is a victim of stalking or something else of that nature. And so I just want
He was granted a protective order, right?
it's
That
been
is correct.
violated.
But
No.
and Mr. Steinfeld will testify that it's already been violated. And that's why his concerns, I believe, are legitimate, and he has every right to be concerned at this point. We understand that this is her first, that she has no prior convictions. However, this is a very serious offense and a very serious series of offenses that if the roles were reversed and this had been a man doing this to a woman, this would be quite frightening and should be treated as such in this case. We asked for a $15,000 surety bond, which is $5,000 per count. Stay away from Mr. Zachary Steinfeld, 200 yards. No contact with him via phone, text, social media, third party, smoke, I don't care what it is. No contact with him or any other party related to him or who had a prior relationship with him, since she is fond of contacting his exes as well. And no alcohol, drugs, or weapons. That's all for the state.
Thank you. Mr. Spisman, I typically let the alleged victims or anybody else chime in at this point before defense counsel gets a final say. Would you have any objection to me following this procedure?
No, Judge, the only thing that I'd ask is it be limited to the warrants that we're here for today. I mean, there is ongoing litigation. You heard the state and Mr. Steinfeld chime in about that this TPO is being violated. That appeared in front of Judge Manning on Monday. It was reset. I frankly disagree with that assessment. So I would just ask that it be kept to what's reasonable and appropriate at a bond hearing rather than discussing things that there are no criminal charges for or have not been substantiated in the least is all I'd ask.
All right. Mr. Steinfeld, if you'd like to unmute your screen and raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. So the warrants I have are for stalking allegations from November 2022, February 11, 23, and February 13, 2023. If you'd like to add any other information with regards to those three incidents, I don't have a violation of a court order before me, so I really cannot touch on the TPO hearings or any orders that have been issued so far.
I understand. If I say something that I'm not allowed to say, please just let me know. I don't know what's connected with what.
Go ahead.
But yeah, so in November, I started to receive a lot of communication, including from various phone numbers that was scary and included a threat that a car would be battered. It appeared that that perhaps Aaron was under the impression that there was a vehicle in front of my house that was a woman's. It was my brother's vehicle.
I don't really need a recitation of the events. Tell
Okay.
me about this tracking device. So you discovered it, and how did you determine that that the defendant allegedly placed it? I mean, why do you believe it was?
Yes, Your Honor. So after the security guard recommended that I get my car checked, I went immediately to an Express Oil and tire engineer. There was a mechanic who found the tracking device on my car. I took a video of him showing me where he put it on my car. And then I went to the courthouse and got the petition for the new protective order. And my father also received a call from Aaron's mother with Aaron on the phone asking, or what appeared to be, according to my dad, Aaron was trying to get my mom, her mom, to tell my dad to basically leave her alone. And that's when my dad said, you know, Aaron, have you told your mom about the tracking device? And she hadn't. He asked the question about whether she knew it was a crime. She did. He asked whether Aaron had
Okay,
told her
so
mother.
I'm going to stop you right there also, because you are relaying to me a conversation that didn't take place with you present.
Sure.
Okay.
So the reason we know that it's Aaron's tracking device is because Officer Cunningham with Atlanta Police's General Crimes Unit did research and found that the tracking device was registered to Aaron.
Okay. I think the other comment was you found a note on your car windshield. So, and you believe that came from Aaron as well?
Yeah, there was a note on my car after I got a massage that said "good massage?" ?
Mhm.
I have handwritten notes from her from other notes, and it looked similar. I'm no handwriting expert, but I don't know who else would have done that. I have no idea who else it could be but her.
I'll let the investigators and the prosecutors take care of that. The only other question I had was, you still believe that she is a threat to you, or at least she may continue this alleged pattern of behavior?
I absolutely still believe that she's a threat to me and to the woman I'm seeing, Maria, who is planning to testify at the hearing earlier this week as well.
Okay.
I look over my shoulder constantly. I have obsessive compulsive tendencies, and I'm checking doors way more than I used to. My OC's on it. It's gone haywire. I worry every night about whether I'm going to see Aaron standing over my bed with a knife. I have a baseball bat next to my bed. I have a tennis racket next to my bed. I have a can of Raid next to my bed, and I'm very afraid. I don't know what to do. I know the protective order is a separate matter, but
the protective order provides the same restrictions as they would in a bond order. So if you believe that the protective order has been violated, I highly recommend you consult with an attorney, okay?
I've filed a petition for contempt. That's what the hearing was about earlier this week. Maria is receiving text. She received a text that said, "If you keep talking to Zach,
Judge,
I'm
I would just object at this
Yeah.
point. I've been very reasonable about allowing this to go.
Your Honor, I'd like to tell you what's going on so I can
Mr.
express
Stein, Mr. Steinfeld, remember you asked me if you feel that you're going beyond the scope to stop you?
Okay.
Okay,
I
so
understand.
let's stick to that agreement, and I'm going to stop you, okay? All right,
Yes, Your Honor.
so, but right now we do have an arrest warrant against Ms. McMahon, and the prosecutor has read through the warrant and has accused her with 3 separate offenses based on those dates I just mentioned. All right, so definitely you still have a right to go through the Superior Court process, but I'm going to move on, okay? But I
There's
appreciate
one
your
thing.
input.
Can I
Yes,
inform you of one thing that I think it might be irrelevant, but I think it's relevant? Investigator Stroner with the Atlanta Police is pursuing a separate arrest warrant against Aaron for the threatening text that Maria received.
Okay, so that would be a separate case and a separate victim, though it will be considered a companion case, all right? If the warrants are approved, all right? Okay, thank you. I think I saw a Miss Wanda, but I don't see her anymore. So we're going to move on to you, Mr. Spisman. Yes, sir.
Thank you, Judge. I'll be relatively brief. There's no prior arrest history for Ms. McMahon. I've been involved in this since day one. We actually consented to the temporary protective order for the 12 months. We, basically agreed to what they had asked for. A motion for contempt was in fact filed. I've reviewed the evidence in that motion for contempt. It's just not my client. We also provided evidence that shows that she cut off communication with the individual that sent some of those text messages. As it relates to the stalking allegations, this all occurred prior to entry of the TPO. And we only found out when we showed up to this motion for contempt that there was a pending arrest warrant here. Ms. McMahon from Alabama drove to Atlanta. She tried to turn herself in 2 days ago, but because of the active shooter situation, she was turned away from the jail. She came back last night again, and she turned herself in. As it relates to a no further contact provision, I mean, obviously, I think Your Honor is going to grant that provision. There's no objection on our end, and there already is one in place. As it relates to the bond, a $15,000 bond, in my humble opinion, for these charges with no arrest is quite high. I appreciate the prosecutor's iteration of the facts. we certainly have some contradictory evidence to that. In addition, Judge, and I think it is important to know that there's two things that have not been discussed. During this time, Miss McMahon was pregnant with what we believe to be Mr. Steinfeld's child, which she lost through a miscarriage, and we have medical evidence of that. And second to that, during this time, Miss McMahon was found to have actually a brain tumor. Also have medical evidence to support that. And part of the condition of having a frontal lobe brain tumor is judgment issues, impulse control. So that being said, Judge, while I appreciate everyone's iteration of the facts, there are some mitigation here that I think should persuade Your Honor to do what is probably more appropriate in this case and issue a total bond of $5,000 with the added condition of no further contact.
And where does she reside?
Judge, her parents live in Alabama. She's been spending a lot of time in Alabama with them to just have some support. And she is undergoing the care of a psychologist for what she is dealing with the trauma and, the aspects of mental health. So she's splitting her time, Judge, between Atlanta for treatment and Alabama for stability. They don't live together. There's no reason to have contact, but it is kind of a split time frame in terms of where she is.
Bond is going to be set at $5,000 on each count. That's going to be a $15,000 signature bond through pretrial services. In addition to being released on a signature bond, Ms. McMahon is also going to be equipped with an ankle monitor, and she's going to be paying for those monitoring fees out of her own pocket per month. She is to stay 200 yards away from Mr. Steinfeld, from any of his known girlfriends or significant partners, and as well as from his immediate family. She is to stay away from wherever he happens to be, whether it's at his home, at a massage envy, or his core yoga, or his favorite restaurant, wherever he happens to be physically standing, as well as his immediate family or his known girlfriend and or significant partner. She's to stay 200 yards away. That is the length of 2 football fields. She's not to communicate with any of these individuals, either in person, through a third party, through a phone, a computer device, or even try to reach anyone or discuss about any of these individuals on social media. As Mr. Smithson, as you are a counsel, I'm sure you'll be advising her that she has to treat all these individuals as if they do not exist. And she has to make sure that she keeps that physical distance away. Her next court date is going to be set to her address at the Grant Street location, if that is still her current address. If she changes it, she would need to make sure that she updates the court with her current mailing address. If she fails to pay her monitoring fees, she could risk the chance of her signature bond being revoked and amended to a surety bond. No illegal drugs, no alcohol, and definitely no weapons and no firearms.
Judge, the only thing I have in terms of a concern is twofold. Is one, with the ankle monitor, having an electronic device attached to her body, I don't know that her medical treatment would not have any type of contradictory impact on that.
Unless I get something from a physician, Mr. Spisman, the last time I checked, you have a JD, not an MD.
That you're right, Judge.
Okay.
Where everything falls through the cracks. And the other thing, Judge, is I presume there will not be any limitations of her ability to travel to Alabama where she resides.
As well, as long as no, she has no limitation
Okay,
to travel as long as she doesn't travel internationally. But if she does, she just needs to make sure she reports back to court, because our warrants tend to go all over the place.
All right, Judge. And does she need to, is pretrial going to be able to fix that ankle monitor? Does she need to set up an outside?
No, I think they do it at the jail. The monitoring service will come to the jail, and before she's released, she needs to be equipped with one, and they'll set up the contract for her payments and so forth.
Okay, so I imagine through second chance, so I'll try to deal with that as well.
All right. Okay.
All right. Thank you, Your Honor.
Your Honor, just to place on the record, the state does object to a signature bond in this case due to the severity of the actions of the defendant.
Understood.
That concludes my business. May I be excused?
Yes, Ms. Paul, thank you very much. Mr. Steinfeld, she does have a signature bond. That means she'll be released. That's due to her limited arrest record. However, she is equipped with an ankle monitor. So if there are any attempts to reach you your partner, your family members, obviously there will be a tracking history, and it will be very little reason to not arrest her.
Thank you,
Okay.
Judge.
All right,
Does-
but I
I have a
still,
question, Your Honor.
yes, sir.
So if she's paying for the device's monitoring, are the monitoring records still going to be property of the state?
It's the property of the prosecutor, yes. They have
Okay.
to report to the prosecutor and to pretrial services. If she violates the no further contact, if she gets arrested again, if she does not report to pretrial once a month, if she violates, if she changes the address and doesn't let the court know, all these are reasons why her signature bond can be revoked, yes. Anything else?
I think I understand. Thank you, Your Honor.
All right. All right,
Thank you,
Ms. Falk, have a great weekend. And Mr. Spisman, you too. Mr. Steinfeld, you too. And courtroom 2, who do we have, please?
Thank you. Am I dismissed, Your Honor?
Yes, you are. Thank you.
Next, Your Honor, we have Brittany Jackson, position number 6. Brittany
Thank you.
Jackson.
Okay, is it Miss Grace or Miss Champion? What's our reset date, by the way?
The reset date is May 18th.
Thank you very much. Okay. This is State versus Brittany Jackson, 23 CR 002-791A. Ms. Jackson has been arrested and charged with battery, domestic violence from a May 4th, 2023 incident. Ms. Jackson, you've been advised of your right to remain silent, and your attorney is Ms. Wills. This is her 5th arrest. I understand that she has an open case in Florida for possession of controlled substance. Ms. Duncan, what's your recommendation?
Yes, Your Honor. In this case that occurred yesterday at 175 Hyacinth Avenue Northwest, a Linda Burton, who is a neighbor of the defendant in this case, had called officers over because she saw something through her open front door. The victim in this case is a minor, 13-year-old EJ. She saw that the defendant in this case was holding EJ by the neck, and EJ stated and told the defendant to let go of EJ and took him next door to her house and called the police. This minor told Miss Burton at that time that he was in his room when his mother walked in and told him to call the police. And he tried to call the police, but the defendant struck him in the back of the head. EJ tried to leave that location, and his mother put her arm around his neck and kept him inside, resulting in multiple scratches on his back and neck. We did get a chance to speak with the witness, who was also the neighbor, Linda Burton. She indicated that this victim is 13 years old and that this is not the first time that this has occurred or that the defendant has been violent towards EJ. She stated that the defendant in this case hits the victim all the time, and stated that she has called the police this time because she heard the victim screaming and did not want the defendant to kill the victim. She stated that she's very concerned for the child's safety and believes that the defendant will kill the child one day. The witness, Ms. Burton, stated to our victim advocate that another person came and picked up the victim when the police arrived and does not know who that person is. We see that this defendant does have 1 cycle in Georgia and 3 cycles out of Florida. There was a 2017 dismissed family violence battery in Florida. So for these reasons, Your Honor, the state's recommendation in this case is going to be a $5,000 total surety bond with no further contact with EJ, unless in conjunction with defects plans, no alcohol, drugs, and weapons, 1-day anger and 1-day anger management. We do not know if Ms. Burton is here. However, we would like to sound for her in case she is here.
Ms. Burton? All right, Ms. Wills?
Thank you, Your Honor, and good afternoon. I would object to that testimony being taken in consideration. That is a neighbor. She does not reside with my client, so she does not necessarily have direct knowledge or information about what happens within my client's household. Ms. Jackson is 31 years old. She has resided in Georgia for the past 5 years, and she does have relatives as well as a support system here. She has attended college and also has certificates from trade schools. She is a single mother. She has 3 children, 2 of which are in the home, the 13-year-old alleged victim, as well as a 3-year-old. She has a 6-year-old who resides in Florida. who she has joint custody of, and she also she pays child support and contributes to financially for that child as well. She is employed through a staffing agency called People Ready. She has been employed with them for the past 3 years, and she does a variety of jobs. She does receive SSI for the 13-year-old child. And so in regard to that, my client states that she and her ex-boyfriend got into an argument, or her ex-partner, excuse me, got into an argument. Her 13-year-old child became agitated. He has a history of acting aggressively. He has ODD, which is oppositional defiant disorder, as well as ADHD. And he has been out of his medication. My client noticed that her child was becoming agitated, and so she, as a precautionary measure, detained him so that to prevent the situation from escalating. She denies hitting the child, choking the child, any of the other allegations that were stated. The child also has a history of violence toward others and was in counseling. Since my client has been arrested, she has already reached out to the child's counselor to inform his counselor about what happened. The child is currently staying with a family friend, Miss Laquana Smith, who's a godmother to one of my client's children. And my client has already put a plan in place that she does not intend to allow the 13-year-old back into her home until they can both meet with a counselor together, and she can have a mental health plan put in place for the 13-year-old so that both she and her 3-year-old are all safe in the home. In regards to the open charge out of Florida, my client states that case is 7 years old. The attorney that she had died during the course of representing her. And essentially the case, it's just been looming open. So I am requesting, for all those reasons, I'm requesting a signature bond. The child is not at risk. She has a plan in place for both the child's safety, shelter, and mental health. If Your Honor is not so inclined, I would ask for a $750 surety bond. Thank you.
And Your Honor, just to clarify with the defense's contentions, this particular witness, Ms. Burton, the neighbor, she did see these incidences with her own eyes because she walked over and the door was open and she saw the acts as alleged in accordance with what she told our victim advocate today.
I think you mentioned that. Thank you. The bond is going to be set at $3,500. That's going to be a surety bond. No illegal drugs, no alcohol, no weapons, and no firearms. No contact with any minor child 16 years and under. Her contact with her minor children shall be in accordance with any defects approved plan and subject to supervised contact until further order of the court. Her next court date is going to be May 18. Thank you.
Thank you, Judge.
Next, Your Honor, we have position number 4, Ms. Forrester.
This is State versus Kadesh Novella Forrester, 23 CR 002-795B. She's charged with battery from a May 4th, 2023 incident. I'm not certain. Well, I'm going to let Mr. Howard. Mr. Howard, could you clarify her record, please? Does she have an open case?
I think it's closed. It said confidential and it had a case number attached to it, but I couldn't click on it because they locked it out.
All right, so it's under seal. Thank you. Ms. Duncan, what's your recommendation for Ms. Forrester?
Yes, Your Honor. In this case, this defendant, from what we saw, this defendant does have 3 cycles of battery in 2013 that was dismissed, and an aggravated assault in 2018, where the defendant pled under first offender to family violence battery. This occurred on yesterday at Chelsea Gardens at 2135 Godby Road in College Park. Sharon Watts, who's the business manager of the apartment complex, heard the defendant arguing with the community manager regarding a security deposit. When Ms. Watts, who is the victim in this case, stepped out to assist, the defendant began yelling at her and demanded the corporate office number. Watts gave her the number and asked her to leave. Ms. Watts then and the community manager stood in front of the defendant, and the defendant began throwing punches and struck Miss Watts in the right eye, causing a cut to bleed below her eye. Defendant admitted to officers that she pushed the victim Watts and said, however, she did not strike her, but later admitted to throwing punches and possibly striking her because she was in her face. We were able to speak to the victim in this case. She did clarify to our victim advocate that she is the business manager at the apartment complex. She further stated to our victim advocate that the defendant always comes in the leasing office and yells at them, and that during this incident, the defendant came in waiting for her security deposit back. And she tried to explain the process to this particular defendant, but the defendant did not like what she was being told. And the victim further stated that the defendant then swung and hit her in the face. She did sustain injury to her eye as well as being hit in the nose where it was bleeding profusely. Ms. Watts stated to our victim advocate that she's had to go back to the doctor today to get an x-ray to make sure that her nose is not broken due to the fact that her nose is very swollen. She stated to our victim advocate that the defendant has moved all of her belongings out of the apartment and has no reason to return back. She stated that they do not want her back at the apartment complex and that she wants no contact with her. For these reasons, Your Honor, given this defendant's history of violent offenses and arrest, we are requesting a $5,000 total surety, a stay away from the Chelsea Gardens at 2135 Godby Road in College Park. No further contact with Sharon Watts. 1-day anger awareness, no alcohol, drugs, and weapons. I do believe that Ms. Watts is on the line and the state would like the court to sound for her when appropriate.
Ms. Watts, would you like to make a statement, or do you believe that the state has covered that adequately?
The statement has covered it adequately.
If you'd like to add something, I need to place you under oath.
Okay.
If you could lower your device so I can see you, there we go. Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. What else would you like to tell me?
That covered it. Ms. Forrester has come into the office on several occasions with the passive aggressive behavior, and I always try to attempt to help her. She just wasn't understanding. She didn't like the answer in which I had given her explanation about the return of how the deposit process is returned to her. And then at that point, she became aggressive.
Does she have any other reason to return to the Chelsea Gardens?
No, not at all. She's moved out, she's returned keys, and we're processing her move out process.
Thank you. Ms. Wills? Oh, is it Ms. Wills? Yeah.
Yes. Ms. Forrester is 28 years old. She is originally from Georgia. She has obtained a high school diploma. She is a single mother of 3 children, an 8-year-old, 3-year-old, and a 1-year-old, and she is currently breastfeeding. She is employed at Burger King, and she's been employed there for the past 3 months. My client denies the allegations as alleged. She states that the employees at the leasing office were aggressive with her, that it was a mutual combat type of situation, that she felt threatened and responded in kind. As it was stated, my client no longer resides there. She has no other business there. There is no risk of reoffense. She has no desire to return there. She has another residence. In regards to my client's open charge, she states that the alleged victim in that case was or is her former partner, who was physically abusive towards her, who there's currently a stay away order between herself and him that was issued against him due to their past violence. For all of those reasons, I would ask for a signature bond. And if Your Honor is not so inclined, I would ask for a $750 surety bond.
Bond set at $2,500. It's a surety bond. No further contact with Sharon Denise Watts. To stay 200 yards away from the entire complex, the Chelsea Gardens at 2135 Godby Road. No alcohol, no illegal drugs, no weapons, and no firearms. Staying away from Chelsea Gardens and Miss Watts means staying 200 yards away from her. You cannot communicate with her in person, through a phone, computer, on social media, or even through a third party. If there is any dispute about funds being owed to Miss Forrester by Chelsea Gardens, she would need to go through a civil process and definitely not contact Ms. Watts or any of the staff members at Chelsea Gardens. Her next court date's May 18. Thank you.
Judge.
Next,
Thank
Your
you.
Honor, we have position number 12, Ms. Patterson.
All right, thank you.
Then we'll go to the interpreter case after that.
All right.
For the Vietnamese interpreter case, the state made an offer and he'd be proceeding on that for a second.
Okay, thank you. We have Alexia Patterson accused of simple battery and criminal trespass from 23 CR 002-801C. The charges stem from a September 12, 2022 incident in Fulton County. And Ms. Patterson, you've been advised of your right to remain silent, and your attorney is Ms. Bronstein. I understand this is a first arrest. Ms. Duncan, what is your recommendation?
Yes, Your Honor, in this case, the defendant is an ex-employee of the victim in this case, and the victim in this case, her name is Keisha Jackson. That's Keisha Jackson, common spelling. They only knew each other for about 5 days. The defendant was employed at Ms. Jackson's business, and she came in after being terminated to return some items, and she was told that she couldn't return them at the time because Ms. Jackson was not there. She came back at a later time during that day and returned those items. However, then she asked to use the restroom. Ms. Jackson indicated to her that she could not because she was no longer an employee or not a customer at that time. And the defendant in this case became angry after going to the bathroom anyway against Ms. Jackson's wishes. She came out of the bathroom, threw a used paper towel at her, and struck her in the face with a closed fist. Ms. Jackson did indicate that she had jaw pain because of being punched by this defendant. And in addition to punching Ms. Jackson before she left the store as a final gesture, she knocked over one of the plants and one of her signs, destroying them. While we understand this is the defendant's first offense, we do have some concerns about the risk of reoffense given this random attack of violence and the potential danger to this victim, given she didn't do anything outside of what she is allowed to do as the employer, which is terminate this employee. For those reasons, Your Honor, the state is going to be requesting a $2,500 total surety, which is $2,000 on the simple battery and $500 on the criminal trespass. No further contact with Keisha Jackson, and a stay away from the incident location, which is at 620 Glen Iris Drive, Northeast. And 1 day anger awareness, no alcohol, drugs, and weapons. We were not able to make contact with Ms. Jackson. However, the state would like the court to sound for Ms. Jackson at the appropriate time.
All right, Ms. Keisha Jackson. All right, Tonya, do you know the name of the establishment, first of all? And Mr. Howard, is there a hold from another jurisdiction for Ms. Patterson?
Not that I'm aware of. Let me pull it.
I have an APD hold. Is it for this case? All right, no, so Mr. Bronstein, if you'd like to proceed.
Yes, Your Honor. So I do want to point out that this case allegedly occurred about 8 months ago, September 2022. There's no allegations of any issues since. Ms. Patterson is 26 years old. She's from Atlanta. Her entire family's here: mom, dad, grandma, brother, aunts, uncles. She did graduate from technical school with a degree in cosmetology. She's between jobs right now, but she's previously worked as a cosmetologist and was about to start something new. As for this case, she does not know where this allegation came from. From the warrant, I was very confused. She was very confused. She has absolutely no prior arrest at 26 years old. And also, I want to point out, I was all very confused because it alleged this occurred in September. Warrant was issued in December. She didn't know about it. She actually says that Keisha Jackson, she didn't know anyone named by that. And she didn't know about the warrant. Otherwise she would have come to handle it.
Yeah.
We're asking for a signature bond.
All right. I'm sorry, Mr. Howard, could you mute your screen, please?
My bad.
And so, I'm sorry, Ms. Bronstein, so your client's saying that she's never worked for Akeisha Jackson at 620 Glen Iris Drive?
She said there was someone by the name of Ashley that she knew, but that she never made violent physical contact with her. And she was very confused by the Keisha.
So she's been to that location, but she's never worked there?
You're right. If I may help, I think the location is named Lashley by Ashley. And the owner is Keisha Jackson. And her middle name is Ashley.
So it's a beauty parlor of some sort?
Yes.
Okay, if she goes by Ashley, that makes sense. She says that these allegations are completely false. And the timeline doesn't really make any sense. With September, warrant in December, now it's May, no issue, no alleged issue since she's not here today. We're asking for a signature bond with whatever conditions the court deems appropriate.
Bond is set at 2,500, 2,000 on the simple battery, 500 on the criminal trespass. That's going to be a signature bond through pretrial services. She has to stay 200 yards away from the Lashley by Ashley at 620 Glen Iris Drive in Atlanta, Georgia. She's to have no further contact with the owner, Keisha Jackson. She's not to communicate with Ms. Jackson in person through a third party, through a phone, a computer, or even discuss the business or Ms. Jackson on social media. If she attempts any of these form of communications, she could lose her signature bond and be back in jail on a surety bond or in no bond status. She is to report to pretrial once a month and not consume any illegal drugs, no alcohol, and not possess any weapons or firearms. Her next court date will be sent to her at the address that we have on file, which is at Mays Court in Atlanta. Is that still a good address?
She told me the Mays Court address is correct.
All right. We will see her in court in the future. Thank you.
And Your Honor, just to clarify, that's 2,500, correct?
Yeah, 2,000 on the battery, 500 on the trespass causing damage to property.
Okay.
Those are signature bonds, Your Honor?
Yes, signature bond through pretrial. She'll have to report to pretrial once a month.
Thank you.
The Ms. Bronstein, I know you are withdrawing from representing Mr. Nguyen. Has the state drafted the plea paperwork for the interpreter to communicate with Mr. Nguyen?
I am drafting that paperwork now as I was notified during this court proceeding that he is accepting that plea.
All right, so as soon as that's done, we can. And courtroom 2 deputy, to whom shall we email the documents for Mr. Nguyen and the interpreter to review?
Ms. Duncan, you can email it to me, Norris.
Okay, will do.
Thank you. Next case, please, Deputy Norris.
We're gonna go to position number 1, Mr. Trevor Dean.
Thank you. This is State versus Trevor Dean, 23 CR 002792D, as in Denmark. Mr. Dean's been accused of battery, domestic violence from a May 1st, 2023 incident. Mr. Dean, you've been advised of your right to remain silent, and your attorney is Ms. Wills. This is Mr. Dean's 6th arrest. I understand he has an open case for DUI. Ms. Duncan, what is your recommendation?
Yes, and I'm sorry, we said, okay, that's the wrong one. My apologies. Yes, in this case, it happened on May 1st at 9370 Martin Road in Roswell. The defendant was in an argument with Erica Dean, his wife, and according to Dean, the wife, her husband struck her in the face, causing her upper lip to split and bleed. They've had previous incidents requiring police assistance, including one where both had bruising on the body and black eyes. He has an open DUI in Fulton County, as Your Honor has stated. Prior dismissed assault and bodily injury to family in 2019 out of Texas. We were attempting to make contact with the victim earlier. And we were not able to make contact. However, there was an unknown male who answered one of the numbers that we made contact with. But he stated that he was going to have the victim give our victim advocate a call back. It's indicated that the victim also has a warrant for an incident that occurred between her and the defendant and yesterday as well. However, she's not in the jailing screen and has not been arrested. We were not able to contact her to get her wishes. So for this reason, given the history of violence between these parties as alleged by the victim in this case, and in accordance with the history as presented, the state is going to be requesting a $4,000 total surety bond, a stay away from 9370 Martin Road in Roswell, no further contact with Erica Dean out of an abundance of caution, one-day anger awareness, and no alcohol, drugs, and weapons.
All right, thank you. Ms. Wills?
Thank you, Judge. My client is 36 years old. He has resided in Georgia for the past 3 years. He has 2 bachelor's degrees, one in accounting and one in finance. He is married to the alleged victim in this case, Miss Erica Dean, and they are both employed. My client is wheelchair bound, and I did have the opportunity to speak with Miss Dean. She stated that my client has a traumatic brain injury, which has impacted his behavior and ability to process different situations and information. She denied the allegations as alleged. She reported to me that she does want Mr. Dean to return back to the home, that they have been in therapy, and that she is not in fear of Mr. Dean. Ms. Dean also stated, as well as my client stated, that it was Mr. Dean's parents who called law enforcement. It was not Ms. Dean, and his parents do not reside in the state.
And Your Honor, we'd like to sound for her just in case she is here, even though we were not able to make contact.
Miss Erica Dean. All right, thank you.
I would just ask that that the court find that there has been an adequate cooling off period. If this incident did occur on the 1st, I believe that the report was made on the 1st, and that my client be allowed to return back to the familial residence. We would also be asking, I'm not sure if I heard 1,000 or 5,000 on the bond.
The state is requesting 4,000.
4,000. Okay, 4,000 surety. I would
I'm
request.
sorry, I'm just trying, oh, go ahead, Ms. Wills. I'm just trying to pull up the warrant. I just want to look up something. Go ahead.
I would ask for $1,000 surety bond. Thank you.
Bond is going to be set at 2,500. It's a surety bond. I'm not sure of the nature of this TBI, but Mr. Dean is scheduled for a jury trial in his other case, 22 CR 006 083D. Not sure what position he is on the jury trial calendar, but for this particular case, his bond is 2,500. It's a surety bond. He's to have no further contact with Erica Dean. He's to stay away from 9370 Martin Road in Roswell, Georgia. He may return to that location one time only with a police officer to retrieve his personal belongings. After that, he has to update the court within 30 days of his release on bond to give us his new address. No contact with Ms. Dean. That means staying 200 yards away from her. Do not communicate with her in any way, form, or manner. If she initiates contact, he's responsible for making sure that he doesn't continue that communication. His next court date is May 18th. And Miss Champion, we will set this case as well as his other case, 22 CR 006 083D on the next SAP calendar. Thank you. All right, courtroom 2, next case, please.
Next, we have position number 3, Mr. Antoine Farrell.
This is Antoine Farrell of Farrell, 23 CR 0027948. Mr. Farrell has been accused of battery, domestic violence from May 4th, 2023. I cannot remember how many cycles he's had. Mr. Farrell, you've been advised of your right to remain silent, and your attorney is Ms. Wills. Mr. Howard? Could you
Yeah, 4 total.
4 cycles, okay?
You got an open ag assault, Superior Court, 20 CP 194268.
All right, thank
That's
you.
ag assault with a deadly weapon, possession of a firearm during the commission.
Thank you. Ms. Duncan?
Yes, this incident occurred on May 4th at 2900 Far Court, South Northwest in Atlanta. John Richardson texted the defendant in this case, his boyfriend, who had been living with for a month, and stated that he needed to pack his items and leave. The defendant in this case came into the bedroom and began yelling at Mr. Richmond. Mr. Richmond tried to leave, and the defendant slammed his hand in the door, grabbed him by the shirt, and pushed him to the ground. Mr. Richmond had lacerations and swelling to his feet, knees, and hands. There is on that ag assault 2 counts and the possession of a firearm, that 20 CP 194268. There's a $25,000 split bond. And in this case, Your Honor, the state is going to be requesting a $4,000 total surety, given this defendant's history with violence offenses. We do have concern about the risk of reoffense. We're going to ask for a stay away from 2900 Far Court South Northwest in Atlanta, and no further contact with John Richmond. 1-day anger awareness, no alcohol, drugs, and weapons, as we do not believe there has been an adequate cooling off period since this instance did just occur yesterday. And we'd like to sound for Mr. Richmond, just in case he is on the line.
John Richmond, if you're present, please unmute and start your video. All right, Ms. Wills.
My client is 27 years old. He has been in Georgia for the past 8 years. He has a son who lives with him, as well as several close friends that have become his support network. He has some college. He is employed by Navan as a travel agent, and he has been employed there for the past 2 years. My client denies the allegations as alleged. He states that he and the alleged victim were residing together. They were in a relationship. However, they had gotten into a disagreement. My client was not speaking with the alleged victim prior to this altercation occurring. The alleged victim then initiated a conversation, attempted to, or did take my client's cell phone, and then it was just a tussle, I guess you could say. My client pursued the alleged victim for the purpose of obtaining his phone. He believes that he grabbed his shirt in the process of doing that, but in no way did he intend to cause any harm to the alleged victim in this case. My client states he has no desire to return back to the residence. He does not want to continue a relationship with the alleged victim. And he is already thinking he's already making plans for other residences upon his release. We would ask for a one-time police escort so that my client can pick up the remaining of his belongings, as well as his child, who is still with the victim at this time, the alleged victim at this time. I would request a signature bond or $1,000 surety bond. I understand that my client is currently on bond for a very serious offense, but my client states that it was related to a shooting that occurred at a club that he was blamed for. So there were several people around. However, he was blamed for the incident. He does not have a history of violence, and he does not have any prior violent convictions to my knowledge. So I would ask for either a signature bond or $1,000 surety bond. Thank you.
On the battery domestic violence, the bonds can be set at $3,000. It is a surety bond. No contact with John Richmond to stay away from 2900 Far Road in Atlanta. He may return one time only with a police officer, a visit that cannot exceed 1 hour to retrieve his personal belongings and his family, his immediate family members. And within 30 days of being released, he must update the court with his current mailing address. No illegal drugs, no alcohol, and if he owns any firearms, he's to surrender them through the authorities for destruction. His next court date is going to be May 18th. Thank you.
Thank you, Judge.
Next, Your Honor, we have position number 5, Mr. Jalen Gregory, position number 5.
This is State versus Jalen Gregory, accused of misdemeanor terroristic threats and acts from 23 CR 002-796G. The alleged offense apparently occurred on May 4th, 2023. And Mr. Gregory, you've been advised of your right to remain silent, and your attorney is Ms. Wills. I understand this is his second arrest. The prior offense appears to be a misdemeanor marijuana arrest. Ms. Duncan. Okay. Apparently this happened at the Westin Hotel. I'm sorry, Ms. Wills, yes.
I'm sorry, I meant to request a breakout room for this case.
Okay.
My apologies.
That's all right. Miss, I think it's Miss Grace who's hosting.
Yes, Judge.
Could you place me, Miss Wills, and Miss Duncan in the breakout, please?
And Miss Falk is in the background, just in case we need to speak with her about this. I can contact her, so I just asked to put her square in there as well.
Okay. Oh, I'm sorry. I didn't see she was there. I thought she was. She left the Zoom.
Yes,
Okay.
her business is concluded, but she's
Okay, Judge, you want yourself, Ms. Duncan, Ms. Falk, and Ms. Wells?
Sure.
Thank you.
Probably going to be put in the Zoom in the middle of a sentence, but a person appeared on iPhone. Who would that be?
Yes, Judge, I'm his mother, and
Who's
I just want to let you guys know that I'm here as
No,
well.
I know. I don't know who that is. I just see the word iPhone. I have no idea who that
Put
is.
your camera on. She can't see you.
All
That's
right.
what she-
All right. Mute your screen, and then change the name iPhone to, I don't know, Jalen's mom, something like that. There's another person here on iPhone. You're wearing a brown jacket. Who is that? You're on mute. I have no idea who you are.
That's the Vietnamese interpreter, Your Honor.
Oh, I see. Okay, thank you. Madam Interpreter, we can only address the case once the defendant has gone through the paperwork. You may have to assist him with the paperwork.
Yes, ma'am. I don't know where else to go.
Oh, all right, that's fine. You're perfectly fine where you are. Deputy Norris, as soon as Mr. Wen receives the plea paperwork, we need to put him in a breakout with Madam Interpreter so that she can go over the paperwork with him. And Miss Duncan, if you can get the interpreter's email so you can send it to her as well, so that she would literally be on the same page with the defendant.
Okay, I would ask that when we come back from the breakout room, since we might go at any second, that the interpreter send me her email in the chat.
Okay. Madam Interpreter, if you could send your email in the chat, that would be great. Thank you. Miss Grace, are you ready to go into breakout?
Yes, Judge, I'm waiting on you guys.
Oh, all right. Sorry.
No problem.
All right, we are resuming our hearing with regards to Jalen Gregory. Ms. Duncan, what would you like the record to reflect?
Yes, Your Honor. In this case for Mr. Gregory, which is position 5 in the charges of terroristic threats and acts, it did occur on yesterday at the Westin Hotel located at 3391 Peachtree Road. Robert Atway, who is the chief engineer, stated that this defendant did come into that place with a ski mask on and several book bags. They exchanged words, and the defendant did indicate at that time that he would shoot, that he owns the place and that he would shoot everyone else. There was a third-party independent witness who was able to corroborate that statement by the defendant, which was a Mr. Doug Cunningham. That's D-O-U-G Cunningham, Cunningham. He heard the threat from the defendant stating that he would shoot Adwell. We did get a chance to speak to Mr. Adwell in this case. He stated that he is an employee at the hotel. He did corroborate the facts as stated in the warrants and documentation, and that he was really concerned and that they were on high alert, given that there was a recent active shooter situation. He stated that the defendant was not a guest at the hotel and approached him and inquired. So that's why he approached him and inquired why he was there. Your Honor, given the nature of the offenses alleged in this case, the state is going to be asking for a $10,000 total surety bond to stay away from the Westin Hotel at 3391 Peachtree Road in Atlanta. No further contact with John Atwell, no alcohol, drugs, and weapons, and the MHET. We do have that concern, given that when this altercation incidents occurred, this defendant was reaching into his book bag as if he was going to grab a weapon, and then was taken to the ground by Mr. Adwell. And I believe Mr. Adwell is here, and the state would like the court to sound for him when appropriate.
And I just want to make sure that I didn't see that in the warrant, but there were no firearms on this defendant at the time of the incident, correct?
I can check, but from what I have, it says that he was, one moment. From what we have, it just states that he reached in there as if he was going to grab a weapon. However, he was taken down before he could do any of that.
All right, so there were no firearms found to date. Otherwise, that's the first thing the officer will be putting out on the warrant. All right, Ms. Wills, you've indicated that you're requesting a signature bond. Co-signer may be an issue. Anything else you'd like to add?
Like, for the record, to state that my client is 18 years old. He is in high school. His mother is present today. I have requested a signature bond. However, he will not be able to have a co-signer at this time. And so I would be asking that the court stay with its recommendation, or its the proposed bond of $2,000 surety.
And just to state for the record, Your Honor, you are correct. There were no weapons located.
Okay, great. Few rare moments that I'm correct. I'm going to take that. Okay, folks, this city has gone through a very jarring event this past week. I know we are still a little jittery about this active shooter event. Tragedy has certainly struck the city, but that does not mitigate or amplify the court's consideration of bond, where we look at the criminal record history, the nature of the circumstances, and the Ayala factors. At the present time, bond is going to be set at $2,000. It's going to be a surety bond. This is not based only on the Ayala factors. It's also going to be based on the information derived in a sidebar. He is to have no further contact with Robert Attaway and no further contact with Doug Cunningham. And he is to stay away 200 yards away from the Westin Hotel premises at 3391 Peachtree Road in Atlanta, Georgia. Mr. Attaway, did you want to add anything else at the present time?
No, Your Honor.
All
I
right.
have nothing to add.
Thank you. Thank you. All right. You're free to go. Thank you. And next court date is going to be May 18. And Ms. Wills, you will do the appropriate request to see if his case is transferable to another accountability court. Okay?
Yes, yes, Your Honor.
Thank you.
And Your Honor, at this time, I request that the Vietnamese interpreter send me her email in the chat. I do have that paperwork back from Officer Norris to send to her so that she can communicate with the pro se defendant.
Sounds good. Thank
Your
you.
Honor,
I have sent it, I have sent it already.
Okay, could you resend it, please, Miss Wendy? Because when she goes in the breakout, she may not get the chat streamed to her.
Okay, so who did I send it to?
ASG LSS Duncan. See
Your
her
Honor,
name? Yes,
Your
Miss-
Honor,
yes, Deputy Norris?
I believe Mr. Gregory mother has something to say. She's been raising her hand.
Miss Gregory, I don't know, I'm sorry, Miss Wills, is that Miss Gregory?
Her name is Tiffany Dillard.
My name is Miss Dillard.
Miss Dillard, Miss Wills has communicated to the court the information that you shared with her. So unless you want to
Okay.
contribute, I believe the information you may be adding might be very sensitive and information that should not be broadcasted on these proceedings, which are live streamed and recorded. All
Okay,
right.
that's fine. Thank you.
Thank you. All right. Next case, please.
Your Honor, I have position number 7, Mr. Ricardo Maturin.
Thank you.
He's actually hearing impaired, so I'm going to turn on the, hey.
So I do have an announcement before we proceed. As it was stated, he is hearing impaired. The state has offered Mr. Mathurin and a plea offer for time served. He is also wanted out of 2 other jurisdictions. And so it would be my preference for this case to be reset till tomorrow so that we can ensure that there is an American Sign Language interpreter in case he does want to accept the plea for the purposes of the record.
I don't need an interpreter, bro. I don't know sign language.
He doesn't know sign language. She is.
Oh,
Reading.
He's
But
reading
he
the
heard-
closed caption, Your Honor.
It's just fine right here.
okay.
He's reading the closed caption and he can
Okay.
actually respond from the closed caption.
All right, let's reset.
Okay, well, I have not had the opportunity to speak with him, so I still would need a breakout room then and he can read my lips. I still need to communicate the plea offer to him.
Okay. Deputy Norris will need to address him as soon as Miss Wills has had a conversation with him through closed captioning.
All right. He said, all right.
Next case, please.
Next, we're gonna go to position number 9, Mr. Brad Moore.
For Mr. Morris, I'm waiving his presence. May I have a breakout, please?
For who?
Oh, wait. Position.
We are on Brad Moore, position 9. Are
Oh,
you talking about 10, Mr. Morris?
yes.
Okay.
I'm sorry.
That's okay. When we have Mr. Morris, we'll do a breakout. Thank you.
Okay.
This is Brad Moore, State versus Moore, 23 CR 002-799E. Mr. Moore has been accused of battery, family violence, and hindering a person from making an emergency phone call from a March 25th, 2023 incident. Mr. Moore has been advised of his right to remain silent, and his attorney is going to be Miss Wills. I understand this is his 9th arrest. Mr. Howard, would you like to elaborate?
Yes. 2022, he got 2 arrests on a probation violation. 2020 failure to appear. The GCIC said 2020 battery DV first offender. There was no further violent contact with Leah Randall. And that's actually printed on the GCIC in the disposition.
Okay. Thank you.
All
Ms.
right.
Duncan?
Yes, Your Honor, that 2020 case is against the same victim as in this case today. That is, I don't know if there was a clerical error as far as her last name, but we have it as Randolph. However, we were able to communicate and she did confirm that that previous incident was with her. With that being said, she did also indicate that she did not want to prosecute. However, in this case, the state does have concerns about possible intimidation of this individual witness. As it is stated, this incident occurred on March 25th, 2023 I'm sorry. And the address is 4005 Meadow Glen Way. Officers responded to that location, and they spoke with Miss Randolph Alea, that's Alyah, and she indicated to officers that her child's father and her had been in a verbal argument that turned physical, and in which he threw a metal broomstick at her, which actually struck her in the face, causing visible swelling and bruising. At this time, apparently they were hosting a housewarming party because they had just moved into a new location. There was a third-party witness there to those events who did also witness that the defendant in this case did grab Miss Randolph and pull her up into the air, so much so that her feet were dangling. And she also witnessed the defendant throw that metal broomstick that struck Miss Randolph in the face. That person's name is AMIE, last name OTIENO. Your Honor, given the history and the incidences between these parties, given that there was a arrest for battery family violence against this same person in 2022, the state is going to be requesting a $6,000 total surety. That's $5,000 on the battery family violence and $1,000 on the hindering 911. The hindering comes from the fact that when the victim in this case did attempt to call 911, as she stated to officers on the date of offense, the defendant heard the operator on the phone, snatched her phone, grabbed it, and threw it into another room. So we're going to be asking for no further contact, third-party contact for the 3 children that they share, to stay away from the incident location, as previously stated on the record, 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law.
The previous case, was that in Henry County?
Yes, it was in Henry County.
Okay, thank you. Yeah, I do see you, Mr. Randolph. If you'd like to unmute, I'd like to place you on the oath if you want to say something.
Sorry, that's my right hand. Yes, I
Do
spoke
you
to both.
solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Okay. What would you like to?
I spoke to both the legal advocate and the prosecutor, I guess his attorney in this case. Like I told them before, the only 2 people at the housewarming party, mind you, when the housewarming party started and the first 911 call was made, Brad he wasn't at the housewarming party. I was throwing a housewarming party. The address that she stated is not correct. My address is 330 Lauren Drive, and that's where the police came to. When they came the first time, all they did was ask Brad to leave peacefully, and he did. After a couple of hours and everybody left except Amy and another individual named Tiffany, me and Amy was already intoxicated when Brad came back and went upstairs. As I told them before, I don't recall the incidents in chronological order, but as Tiffany, the other sober party there, because Amy O and Tiano was not credible. She was drunk. She's the one that talked to the police officer. And I even told the police officer I did not recall getting hit with a broom. Tiffany also has stated Brad never threw anything at me. Me and Amy got physical before Brad ever came downstairs. Me and Brad had an incident in 2020, and I will say he served his time. I'm not a woman to allow a man to put his hands on me, and I showed Brad that in 2020. We have 3 children. We live in the home together. He's a good father, and he supports us. We live together. We see a counselor 2 times a week to work on our relationship. And as I told them before, I haven't had any problems since 2020 with Brad, and we've been together for 10 years. So since 2020, he hasn't been physical with me. The whole I have pictures from the very day after I could submit to anybody. I didn't have bruising on my face whatsoever the very next day, and I don't wear makeup, as you can see. So I'm really not sure where they got I had bruising on my face or what Amy said. I've also spoke to Amy since then, and she says she doesn't recall that night whatsoever.
All right. Ms. Wills?
Thank you, Judge. My client is 27 years old. As it was stated, incident occurred back in March. Mr. Moore states that he was unaware of this warrant. He has been in Georgia for the majority of his life. He was originally born in New Jersey. However, he has spent the large majority of his life in Georgia. He does have a high school diploma. He has 3 children with Ms. Randolph, and Ms. Randolph's 7-year-old son also resides in the home with them. Mr. Moore reports that he is employed by Right Choice of Care, where he manages child activities and also transportation, and he has been employed there for the past 6 years. He states that he is no longer on probation, and he denies the allegations as alleged. And I would just ask the court to take in consideration what Ms. Randolph presented to the court today. She is not fearful. She would like for Mr. Moore to return home. I would ask that if there is no stay away order in place, that he be allowed to return home. There's been more than enough time for a cool off period to occur. There has been no other incidents or arrests. And if Your Honor is so inclined, I would ask for a signature on bond. However, if not, I would ask for a $8,000 surety bond. Thank you.
All right. On the battery charge, it's going to be a $2,000 surety. On the hindering a person, it's a $500 surety. I'm not sure where Miss Aliyah Randolph lives, but at the present time, there is going to be no further contact. And I'm not sure if Mr. Moore lives at the same location. I think Miss Randolph indicated they do, but I'm really confused as to the address. So Ms. Duncan, do you have a good address from where he has to stay away, where Ms. Randolph lives?
The address that we have, and according to the warrant, is that 4005 Meadow Glen Way. However, Miss Randolph did state a different address. Miss Randolph, do you reside with the defendant, and what is your address?
I have my own house and Brad stays with me at 330 Lauren Drive. That address that you're saying, I've never heard of that address. They didn't respond there. They responded both times at 330.
Okay.
Also, Brad is the one that takes care of my kids when I work. Right Choice of Care is his family's business, and my children.
Miss Randolph, I've heard your part. So what you're going to do is speak to the Victim Advocates Division, and maybe they can share the warrant and the police report with you. And if there are any corrections to be made, then I think you need to take a step in that direction. Okay? Because right now I have your version of events, I have the police officer's version of events, and I have the defense's version of events. All right? So if you want to tell me that this person is not credible and so forth, that's your personal opinion. But right now, because of this situation, you and Mr. Moore have made it the court's business. And my business is to make sure that I issue the correct bond. And the bond at the present time is $2,500 surety bond. He's to have no contact with Aliyah Randolph. He's to stay away from wherever Miss Randolph lives, wherever that address may be. And he can have third-party transfer of child or children that he shares with Miss Randolph. No alcohol, no drugs, no weapons, and no firearms. And while he's out on bond, the court would require him to get a refresher of the domestic violence intervention program, which means that within 60 days of being released, he needs to enroll in a qualified DVIP program. Thank you.
And Your Honor, can he also have a one-time police escort to gather his belongings?
I don't know where to send him.
And I'm sorry, Judge, not to interrupt. Our victim advocate did indicate to me that she has the address as 330 Lauren Drive.
Is that the correct address?
That is the address that the victim in this case stated she lives at. And she said, yes.
Is that in Fairburn or in Atlanta?
Fairburn.
Okay. Then he can return to that location one time only with a police officer to retrieve his personal belongings. All right, thank you. Next court date is May 18th. If he makes bond, then we will send him a new court date to his whatever address he provides upon his release, which must be done within 30 days of release. Thank you.
Position 2.
Your Honor, can we put Ms. Wills in courtroom 3 in the breakout?
Certainly. Miss Grace, if you could place Kelly Wills and courtroom 3 in a breakout, please.
Okay,
And
Judge.
then, and Deputy Morris, who do we have in courtroom 2? Mr. Morris?
Position 2.
Position 2. Okay, that would be Mohammed Drame. Okay. Mr. Drame's case number is 23 CR 0027993D. He's been accused of simple battery from May 4th, 2023. This is his first arrest. Mr. Drame, you've been advised of your right to remain silent. Your attorney is going to be Ms. Bronstein. Ms. Duncan, first arrest, what's the recommendation?
Your Honor, just to clarify for the record, we have something different based on our GCIC pool. We see 18 cycles.
Wow, what a difference. Okay, go ahead.
With a simple battery family violence conviction in 2021 and a parole violation in 2021 and 2022 for 2 counts, and an open family violence battery cruelty to children in the second
I don't believe that's the correct person.
Yeah, hold on.
No.
I have a February 24th, 97 DOB. So is that the correct DOB on your GCIC?
1 second.
That's what's on mine.
Let me check. I beg the court's indulgence for one. moment. Let's see. And no. What date of birth did you say, Your Honor?
February 24th, 1997.
Yes, Your Honor, we have a 18 cycles out of Georgia and a multi-state offender.
Wow.
We have a date of birth. I'm sorry, the date of birth that we see 2 dates of birth because this defendant does have a couple aliases. We see July 24th, 1997, July 24th, 1994, and the date that we just stated on the record.
I mean, someone else might have used his name, but that's not him.
All right. Right now, I'm going to go with the pretrial report from Mr. Howard. And if you believe that there is a difference, the prosecutors can direct the jail to fingerprint him and verify his identity. But they've already fingerprinted him and booked him, and this is the information we have.
Okay, and our office is also double checking the GCIC, and we can go ahead and I'll present the facts as we have them, and they should let you know before we're done with the case.
All right, go ahead and tell me what's the state's recommendation.
Okay, in this case for position 2, it occurred yesterday at the Extended Stay Hotel located at 3329 Old Milton Parkway in Alpharetta. The defendant got into a verbal argument with Ashley Taylor, a guest at the hotel. He leaned over the counter and struck Miss Taylor with a closed fist in the left side of her face. The defendant knocked the phone out of her hand and came around the counter and struck her again with the closed fist on the arms and hands. We were able to speak with the victim in this case. She did state that she's currently staying at that Extended Stay Hotel and the defendant works at the hotel. She indicated to our victim advocate that she had paid for up to Sunday, but when she came back in from work, the defendant told her that she only paid till Thursday. She indicated to our victim advocate that they began to argue about extending her stay at the hotel, and she began to record this incident on her phone. She stated that at that time, the defendant hit the phone out of her hand and knocked it out of her hand, and then that's when he became violent. She stated that she wants no contact with this defendant. Based on our pool of the GCIC, our recommendation with those 18 cycles that do include violent convictions is a $2,500 surety. I'm sorry, there's a current $2,500 surety. We're asking that it be increased to a $4,000 surety. Stay away from that extended stay hotel, which the address was previously stated on the record. No further contact with Ashley Taylor. 1 day anger awareness, no alcohol, drugs, and weapons. And the state would like the court to sound for Ms. Taylor when appropriate.
All right. Ms. Taylor is on the Zoom. Ms. Taylor, would you like to say anything else in addition, anything new other than what Ms. Duncan has reported?
No, Your Honor.
All right, thank you. Ms. Bronstein?
Yes, Your Honor. My client has no criminal history whatsoever. He was a naturalized citizen last year. If he had violent convictions, that would not have been a thing. So I don't know why the state is falsely putting this forward, but this is not it. He would not have become a naturalized citizen with all of those convictions and violent convictions on his record. It's simply not true. He is from Gambia. He moved here when he was in 2015 to join his family. His family was here and to pursue education. He is a full-time student at Atlanta Metropolitan College. He is studying computer science and he is close to getting his AA. And after he gets that, he's going to transfer to Georgia State to get his bachelor's. He actually has a computer science internship starting on May 13th that he's really excited about for the company Accenture. Like I said, he is a naturalized citizen. His family is here. His mother and sisters live here. For this case, we are going to certainly need to look at the video from the hotel. He does work there, and our position is that, and again, we need to look at the video. However, the state's recitation of their version of events is not at all ours. I don't want to get into it without reviewing the video. However, it looks like there was that the person who was staying there, my understanding is that from management, as well as that, you know, that it had not been paid, and that Mr. Drama was defending himself. Again, I believe the videos from the hotel will show that we are asking for a signature bond on this case.
All right, thank you.
If the complaining witness does leave the hotel, that he be able to return back.
No. We're not going to go there. We're not going to go there. Anything else?
And Your Honor, just to clarify for the record, based on defense's contentions, it's not the state's intention to provide false criminal history. That's what we have, and that's why we're verifying it. And based on what we have right now, I'm still waiting, and that's the state's position.
Well, it's very curious. Do you have any reason to disbelieve that he's a naturalized citizen from last year?
We have no knowledge of that.
If he's got 18 cycles, I doubt the State Department would have approved the application for naturalization.
We have 18 cycles and a multi-state offender. However, we're, like I said, we're checking on that. And if that is,
y'all need to get him fingerprinted if y'all believe that's a issue. So you have 24 hours before he gets released from jail. Bond is set at $2,500. It's a signature bond through pretrial services. He's to report to pretrial once a month, and he cannot afford to get arrested again for anything else. Mr. Drame, you are to have no contact with Miss Ashley Taylor, which means you have to stay 200 yards away from her and not communicate with her in any way, form, or manner, even on social media. You cannot return to the extended stay location at 3329 Old Milton Parkway, unless Miss Ashley Taylor is has legally vacated the premises. And also if the hotel is still employing you. So those two conditions must be met for you to return to that location. Number one, Miss Taylor has vacated the premises legally, and number two, that you are still employed by that hotel. So Miss Bronstein, does your client live at that facility as well?
No, Your Honor.
Okay.
He works there. And Your Honor, just for the record, I want to make sure that we sound for Miss Taylor, just in case she is.
She's already spoken. She said she didn't have anything else to add.
Okay.
All right.
And according to our victim advocate, she still lives there.
Well, that's what I said. He can only return to the hotel if she legally vacates the premises and he is still employed by that facility, that hotel facility. All right. No illegal drugs, no weapons, and no alcohol. And like I said, he needs to report once a month. And if he gets arrested again or if he violates the conditions, the bond will be revoked. Thank you.
Could you restate the amount, Your Honor?
2,500 signature bonds for pre-trial.
Thank you.
Mhm. All right, next case, please, Deputy Norris.
This Blunt, position 11.
Thank you. Repeat the name again.
Position number 11.
Okay, Mr. Hong Wen, is that correct?
Yes.
Okay. Our interpreter is present, Miss Wendy. Could you please unmute? Thank you. Please raise your right hand, Miss Wendy. Do you solemnly swear and affirm that the information you translate from English to Vietnamese and vice versa will be a true and correct translation with no changes or embellishments?
I do.
Thank you. This is State of Georgia versus Hong Wen, accused of criminal trespass.
Đây là ở Fulton County, họ chính phủ ở đây họ kết tội anh Hồng Nguyễn về cái tội đi tới những cái chỗ khác không có sự chấp nhận của người ta.
His case number is 23 CR 002 800Y.
Và cái vụ án này là có số là 23CA002800Y.
You have a right to remain silent. Anything you say in open court, your statements can and will be used against you.
Anh có quyền lợi là không có cần phải nói gì hết. Những cái gì mà anh nói là họ sẽ dùng những cái câu nói của anh để mà kết tội anh sau này.
You have a right to an attorney, and I understand you were represented by Miss Wills. I think, was it Miss Wills?
It's a plea, Your Honor.
I understand.
Bronstein.
Miss Bronston. He was represented by Miss Emily Bronston.
So because he's doing the plea, since I
No, I understand. Let me just finish my soliloquy, then I understand. Thank you. Miss Wendy, please explain that he has a right to an attorney and he was represented by public defense attorney Emily Bronston.
Anh có cái quyền lợi là mướn luật sư của anh, và ở tòa họ hiểu là anh đã có người đại diện cho anh, có luật sư đại diện cho anh là cô Emily Bronstein.
But in light of your decision to accept the state's plea offer, the public defense attorney is withdrawing from representing you.
Và vì lý do là anh sẽ chấp nhận cái sự đòi hỏi của chính phủ, nên cô Emily, cô luật sư cô không có là luật sư của anh nữa.
If you decide to proceed with this plea offer, a conviction will be on your record.
Nếu mà anh vẫn tiếp tục tiếp diễn để nhận cái sự khoan hồng của tòa đó, thì cái sự nhận tội của anh nó sẽ ở trong cái hồ sơ của anh.
This may affect different aspects of your life, like your job or your residency in this country.
Và vì vậy đó là nó có thể làm hại cho cái cuộc sống của anh sau này, là giống như là anh đi kiếm việc làm, hoặc là những cái gì sau này của anh đó là khi mà người ta lập cái hồ sơ của anh ra, người ta sẽ thấy là anh có tội.
Are you still willing to move forward without an attorney? That was the question. Is he still willing to move
Cô
forward
tòa
without an
của
attorney? Go ahead.
anh vẫn có muốn tiếp tục làm hay không khi mà anh đã không có luật sư nữa?
Không, tôi không muốn. Không muốn cô.
Anh có muốn tiếp tục nhận cái sự khoan hồng, những cái điều của chính phủ hay không? Biết rằng anh không còn có luật sư nữa.
Nó không còn, tôi không có lựa chọn, tôi phải chọn thôi. Tôi chịu đó cô. Tôi chịu cô. Tôi lấy cái điều đó cô.
Yes ma'am. Yes ma'am. I think I will accept the deal.
All right. Please raise your right hand. Mr. Nguyen, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Anh đưa cái tay phải lên và anh thề là tất cả những cái lời khai của anh ngày hôm nay là sự thật và không có gì ngoài sự thật hết.
Yes, sir.
Ms. Duncan, what is the
I
plea
swear.
offer? Ms. Duncan, what's the plea offer?
The plea offer in this case for the one count of criminal trespass is 12 months to serve 1 day credit for time served, with the balance suspended and a stay away from the College Park MARTA station located at 3800 East Main Street and MARTA in accordance with any active suspension.
Ms. Wendy?
Và cái tội của anh á, họ sẽ xử là 12 tháng nhưng với 1 ngày ở trong tù. Thì sau khi anh đã ở tù 1 ngày đó thì tất cả những cái tháng trước, cái tháng còn lại đó họ sẽ ngừng lại. Và anh trong cái vòng 12 tháng đó anh không có được tới cái chỗ College Park MARTA Station ở địa chỉ là 3800 East Main Street, College Park.
Mr. Nguyen, do you agree to these terms?
Anh có bằng lòng hay không? Với những điều kiện này không?
Cho tôi hỏi một câu hỏi đơn giản được không?
Can I ask a question, please?
Yes.
Nói với văn tòa tôi không tới cái chỗ mà trạm xe lửa của Mota đó, nhưng mà tôi có thể đi xe bus được không?
Đi đâu?
Cần xe bus đó, xe bus của cái trạm Mota, trạm xe bus đó. Cái lúc tôi tới việc làm, tôi cần xe bus Mota để tôi đi làm kiếm sống, có thể cho tôi cái điều kiện đó được không?
So I know that I cannot be at the station, the College Park MARTA station, but sometimes I need to take the bus to go to my work. So can I just get there, take the bus?
He has to go to another station to get the
Anh không có
bus.
thể. Anh có thể đi xe bus được nhưng mà anh không có thể nào tới cái chỗ College Park MARTA Station được. Anh có thể đi xe bus từ cái chỗ khác nha, từ cái trạm khác chứ không được tới cái trạm này nữa.
Okay, I understand.
And he has to stay away for 1 year.
Và anh không có được tới cái trạm xe bus này 1 năm nha.
Dạ vâng rồi. Tôi nghe rồi.
Yes.
Does he still want to proceed with the plea?
Anh có vẫn muốn làm theo cái vấn đề mà nhà nước họ ra điều kiện cho anh hay không? Yes, ma'am.
Does he agree with the facts supporting this case, that it occurred in Fulton County and that he is the correct defendant?
Anh có đồng ý với tất cả những cái gì mà những cái tội mà họ viết ra đó, và anh đúng là cái người mà họ phạt anh không? Đúng cái tên trong cái giấy này không? Yes, correct.
Mr. Nguyen,
anh ở trong cái tờ giấy đó.
Dạ. Không, họ chưa đưa cái tờ giấy gì hết.
What? Cái gì?
Họ chưa có đưa cho tôi cái tờ giấy nào hết luôn. Nãy giờ họ
So I have not received any papers.
I'm going to repeat my question. Please translate.
Cô tòa cô sẽ hỏi lại cái câu hỏi này nha.
dạ dạ.
He needs to listen carefully to the question and answer it. Otherwise, I'm going to reset the case.
Anh phải nghe cái câu nói của cô tòa rất là kỹ càng và anh phải trả lời trong cái câu hỏi này nha, nếu không là cô sẽ dời ngày lại đó.
And he may have to stay in the jail until I'm ready to hear the case again.
Và anh khi mà cô dời ngày lại là anh phải ở trong tù cho tới chừng nào mà cô cho anh đi ra để nói chuyện lại đó.
So he needs to listen very carefully.
Anh phải nghe rất là kỹ càng nha.
Tôi nghe không tòa.
Yes, I will try to listen.
Does he agree with the facts surrounding this case?
Anh có đồng ý là tất cả những cái gì người ta nói là đúng hay không?
Dạ đúng, đồng ý.
Yes.
Does he agree that he is the correct defendant in this case?
Anh có đồng ý anh là người bị buộc tội ngày hôm nay hay không?
Dạ đồng ý.
Yes.
And does he agree that the incident occurred in Fulton County, Georgia?
Và anh có đồng ý là cái chuyện này xảy ra ở Fulton County, tiểu bang Georgia không?
Đồng ý.
I agree.
Has he consumed any medicine or alcohol recently?
Trong vòng thời gian vừa rồi đó, anh có uống rượu hay là phê phun gì hay không?
Không.
No.
Has he understood everything so far?
Anh hiểu tất cả những cái gì hiện tại bây giờ đang nói phải không?
Hiểu.
I understand.
Is anyone forcing him to plead guilty today?
Có ai bắt buộc anh phải nhận tội ngày hôm nay không?
Không.
No ma'am.
Is he entering a guilty plea freely, willingly, and knowingly?
Anh nhận tội với sự tự do phải không? Không ai bắt buộc phải không?
Dạ đúng không?
That's correct, ma'am.
Does he understand that if he pleads guilty today, he will not have a trial? He will not be able to confront his accuser?
Anh có hiểu là khi mà anh nhận tội hôm nay là sẽ không có ra tòa nữa và anh sẽ không có được nói chuyện với những người buộc tội của anh.
Dạ biết rồi.
He will not be able
Yes,
to.
I know.
He will not be able to examine witnesses.
Anh cũng không có thể có quyền để nói chuyện với những người nhân chứng.
And have the prosecutor
Yes.
prove the charge against him beyond a reasonable doubt.
Và anh bắt buộc cái người bồi thẩm đoàn đó là chứng nhận là cái tội của anh. Người ta không có cần phải làm như vậy, anh biết không? Yes.
How does he plead to one count of criminal trespass?
Như vậy thì anh sẽ nói làm sao với tòa về cái vấn đề là người ta buộc tội anh đi tới những cái chỗ mà không có sự đồng ý của người khác.
Tôi biết cái đó là nói với bà cậu, tôi biết đó là lỗi của tôi, nhưng mà tôi chỉ muốn đi làm mình đi làm giờ thôi, nhưng mà bây giờ ông tòa nó không cho tôi tới đó thì tôi sẽ không tới đó nữa.
That's a very long response. What was his